Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, which means I go across the street, I try cases, and I win cases. So today we're reacting to something that's happening in the Gunna case. Now, if you remember, Gunna is part of YSL, but before we get to that, this, like all of our episodes, are brought to you by what? By eforms.com. That's eforms.com. What did I say? I said eforms.com. Now remember, if you have anything legal that you're trying to do, whether it be a will, power of attorney, or let's say your grandma's in the basement and, you know, she's tweaking out with her friends and she's just not, you're not feeling in love with grandma and you want to get her out of your house. Well, you can get an eviction form right on eforms.com. I don't care what state you're in. They've got them for all 50 states. Why hire a guy like me? Because I would just charge you a shit ton of money, and guess where I'd go? I'd go to eforms.com. They're a great resource. Bill of sale. You're going to sell your grandma a motorcycle. Whatever grandma needs, and I'm using grandma euphemistically, of course, but you get my point. You need a form for any kind of legal thing, go to eforms.com and click the link below. So, Gunna, as you know, he's caught up in that RICO involving YSL. YSL, you know, Young Slime Life. Now, one of the things while you're sitting in jail and you're waiting for your case to be called and you're either being held without bond or a bond so high that you can't make it, your mind starts to fucking wander. You think, oh, is my lawyer doing anything? I haven't heard from my lawyer. I don't know what the fuck he's doing. I want to get the fuck out of here. And what happens is they make a pitch to the judge to try to get you out. And the only way the judge would change the bond conditions is if there's a change in circumstances. Okay? So if the judge sets a bond, and even if it's another judge or the same judge, they don't like to reverse each other or change their own ruling. Because if, you know, what's different? Why would I change it now? I was right then, I'm right now. So let's just see what this judge has to say.
I just got to do what I got to do. All right, Mr. Sato, anything, sir?
Now, they just had, this is like the judge is going to rule here. They just had their arguments about making another pitch to change the bond conditions.
Your Honor, thank you. Okay, all right. Here's where the court's kind of, where I think all of you are kind of stuck between. There is the standard for bond, which is the preponderance of the evidence. And then there is, and that proffers are authorized by our state Supreme Court for bond. They are not offered or not authorized unless otherwise agreed to for trial. And
so what the judge is talking about there is, I didn't hear the beginning part of this argument, but I can tell you exactly I know what the judge is talking about. The judge is talking about an argument that the prosecutor made. And the prosecutor made some argument saying, so-and-so is going to say this at trial, so-and-so said this, so-and-so said this. In other words, using hearsay statements in court and not having the people testify. You can do that when setting bond. The defense is free to do the same thing. You know, you can proffer an argument. Proffer means to give a showing. Proffer an argument that, you know, he's got a place to live, he's supported by his family, he's got, you know, whatever. And then, but that same standard of using proffered testimony, in other words, not having a live witness, but just saying what they would say, is not allowed in court when you are actually in trial. They have to testify. They have to be subject to cross-examination. It's called your Sixth Amendment right to confrontation.
That strict burden or strict proof is required for that particular proffer as a result to a issue of proof at trial. So we're stuck in between the two burdens in this case. We also acknowledge the fact that, you know, the defendants are presumed to be innocent, and this particular system.
So one of the things, when you have a lawyer that's coming in to make another pitch to get his client out, the lawyer probably doesn't want to do it because the lawyer probably knows that this is going to go nowhere. But he kind of have to do it in a sense because the client's unhappy, the client's sitting there, the client wants to get out, and if you don't do it, he's going to say, you're not doing anything for me, and then get another lawyer. So you can probably tell there might be a little bit of a rift between Gunna and his lawyers. Maybe so, maybe not. But Occams Razor says that's probably the case. And that means the simplest answer is usually the right answer.
Authorizes the court to consider bond based on statute as well as case law, and I have done so in this particular case, and will continue to do so. The other challenge that our imperfect system kind of just hasn't figured out a way to kind of deal with, other than reconsidering the issue of bond and changing circumstances of bond, is acknowledged for proof that may or may not come at trial, but the state bears that burden at this point in time.
So what he's saying is, I heard what the proffered testimony is, and it may or may not happen, because if they have trial, a witness may not show up, or may say something completely different. That just happened in a case that I'm trying right now. But that's not the standard that he looks at.
And it's not a perfect system in the sense that we won't know until that time whether or not many of these statements that have been proffered by the state come to pass or come to fruition.
And one of the things when the state proffers a statement, the judge takes them at face value. He doesn't analyze their credibility.
That's no consultation or consolation for your client, Mr. Samuel and Mr. Sadow. And but unfortunately, that's the best that the system can offer at this point in time, given the status of the case law and the like. The only thing I can potentially do is, like I said, I will try the case as expeditiously as possible.
And you have a right to a speedy trial. Generally, that means about 60 days from the demand of your speedy trial. But when you're in a case like this, I guarantee you, the defense lawyers don't want a speedy trial, because it's a large case. I think, what did they say, like 23 or 24 defendants in this case? And you have got a mountain of evidence, witness testimony, probably surveillance, just all kinds of different evidence, forensics. So because it's so voluminous, you don't want your lawyer to be under the gun like that, because they just won't be able to be prepared.
But at this point in time, I don't find any change in circumstances that would allow me to, or move me from changing my decision as to bond. And if anybody's...
And then you're in the back of the courtroom. You hear that? Those are some rumblings. Let me back it up just a bit.
As to bond. And if anybody's in the gallery and you can't otherwise control yourself, or otherwise you want to make any inappropriate comments, then you can leave at this point in time. No harm will come, or nothing else will occur. But if you remain in this courtroom and make any outbursts, I'll have you arrested.
So they're sitting there grumbling as they're leaving the courtroom, and they're pissed off, of course, their family members not being heard, they probably think. But the last thing you want to do is alienate the judge. And all of a sudden, guess what? They come to trial. Oh, you were the one that did that? Well, you're not allowed in my courtroom. And they shut up right away. And what the judge is talking about, I'll have you arrested, are things that are happening right in front of the judge. There are two types of contempt, is what we call it. There's criminal contempt and civil contempt. Generally, on civil contempt, you have the keys to the jail. You comply with the condition, or you go to jail. One of the two. And generally, you have the keys to the jail. In criminal contempt, the judge can sentence you up to 6 months, generally, for things that happen right in front of the judge. So if you fail to testify, you're ordered to testify and you won't testify, the judge can put you in jail up to 6 months. Or if you're rowdy in the courtroom and you're disrespecting the court, or you're not obeying the court's order, to remain silent in the courtroom and decorum, and that happens right in front of the judge can fine you in contempt. That's criminal contempt. He can just put you in jail for 30 days plus. And I've seen it where somebody will act out, and they'll, do you want any more time? Yeah, judge, give me more time. Okay, that's another 30 days. You want some more? Yeah, give me some more. You want another one? So why the fuck would you do that? It's just stupid. But I've seen it. I've seen it happen. So this has been our reaction to Gunna and denied bond. So if he switches lawyers, I don't think he's going to, but he might. That would be because he's trying to get out. He's not happy with his lawyers. And that's really common, really common. So shout out to Michael Rivers, our content genius. Shout out to Jaylap for our intro and Percy DeMac for our outro. Both of them are fucking amazing. Make sure you subscribe, follow us on Instagram, follow us on Twitter, follow us on Patreon, and the merch is on its way, so keep an eye out for that. Make sure you sign up for eforums.com, and we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please, is that my God?